Many people ask me about the situation concerning a house owned by in which a married couple are living when they're about to break up or divorce or whatever. And usually the question that arises is, if the house is in one of their names, can that person sell the house without the consent of the other? Now, it's important to say that if the house is in joint names, both must join in the transfer. So, if I'm a joint owner of a house with my wife, and I try to sell the house, obviously I can't do it under her signature. Now, there's legislation in Ireland as well which prevents anybody who is the sole owner of a house and who is married from selling that house without the consent of their spouse. There are some very narrow, limited exceptions to this, but it's that is the general situation. Of course, what happens basically by the way, this restriction that only applies where the people are married. It's different when there are two people just living together, and I'll come to that in a few minutes. But this protection for a spouse from having the house sold out over his or her head only applies to people who are actually married. When people decide to get divorced or get separated or go for a judicial separation or whatever, the best course of action always is, and I'm tired of explaining this to people, is to try to mediate, each get a solicitor and mediate between them as to how they divide up the property. However, sometimes it's impossible to do that, so if it goes to court, the judge will look at everything. He will look at the assets the wife has, the assets the husband has, whether there are kids there, whether one of the parties has a pension, whether one of the parties has more money than the other, etc. Everything, including the family home, is put into the pot, and the pot is then divided as the judge sees, in a way that the judge will regard as fair between both parties. And as I said, there's a whole lot of things will be taken into account there. Now, it's important to remember there are two items which don't go into that general pot. One is where a spouse has earned money themselves before getting married. That's their own money. That doesn't go in. Where one of the spouses inherits money from a relative, say, or gets a gift of money or property from somebody else. That doesn't go into the mix. Now, the situation with cohabitees is that if you're living with somebody, you can, if you're separating, you can apply for part of their property, but only if you can prove that you were together in an intimate and loving relationship. If there are no children, then you have to prove that has been the case for 5 years. If there are children, you'll have to prove that was the case for 2 years. And two brief tips. People often ask me, what is the status of a prenuptial agreement? A prenuptial agreement is not binding. It is not binding, but it does, in a divorce situation, when the judge is deciding on how property is to be divided up, it does serve as a guide, and judges often refer to it. But as I say, it is not legally binding in itself. And one other tip, when the people often ask me if the marriage is broken down and relationships are very bad and they're moving towards a divorce or judicial separation or an agreed separation, should one of the parties leave the house in the meantime? My advice would be no. Both parties, regardless, I know the atmosphere won't be very good and it's not very pleasant, etc. We all appreciate that. But both parties, each party should stay in the house until such time as the matter is finalised. I can't find anything about this being a disadvantage in the legislation, but in practice, in court cases, it has worked out, in my opinion, to be a disadvantage if you actually leave the family home before the matter is finalised.